The Michelle Troconis trial just got underway last week. There's only been a few days of trial. Nothing too exciting going on so far with the trial. Just some of the very initial investigations, some of the body cam footage you're able to see, some of the security footage you're able to see, just some very basics, just laying the foundation really for what's going to really be coming up later, probably this week or maybe the following week. And we will jump into anything that gets exciting, obviously. But so far, nothing too exciting. But there were certain things that everyone has questions about, and which we're going to answer, because that's what we do here. We don't just provide the what, we provide the why. But first, to give a little bit of background information about the story, you've got this victim, Jennifer Dulas. Jennifer Dulas was married to Fotis Dulas. Fotis Dulas and Jennifer went through a nasty divorce, which involved a nasty custody battle. And at some point, actually, Fotis completely lost custody because he was just ignoring the court's orders, which is never a good idea. So the court awarded full custody to Jennifer Dulas. Obviously, Fotis was not so excited about that, and he did get some sort of parenting rights or visitation rights when there was someone supervising him. So obviously, that's not something that he wants. So he was not exactly in the greatest place. So the story goes that on May 24th, 2019, Jennifer Dulas is reported missing by her nanny. She doesn't come home to help with the kids, take care of the kids, and that is when all these red flags are being raised, because she was not that type of mother. She was always very responsible, always making sure to be there when her kids need her, and all of a sudden she just drops off the face of the earth. So she's reported missing, and the last time actually that they catch her on a video she's actually driving her car at that time is around 10:25 in the morning, and this is already 7 p.m. at night. Nobody knows what happened to her. But they do locate eventually her car, which is at a nearby park. There is some blood splattering in her home in the garage, which the police believe what happened here is that Fotis lied in wait, broke into her house essentially because they were living already separately, obviously, and he made his way into the house. This is what the story is believed by the investigators and the police and the prosecution, that he broke into the house, waited for her to come home. She came home, and that's when he murdered her. And then he threw her body in her car and somehow disposed of it, which unfortunately they have not been able to locate the body even up until today. So this is going on since 2019. They cannot locate that body, which of course hurts the prosecution's case, because then you can get the medical examiner, you can get a lot more details, a lot more evidence about what happened to her. But her body is not found. So you've got, it seems that Fotis Dulas was involved. That's what the police believe anyway. But his trial is never going to happen, because he did something to himself that he's not able to stand trial anymore. So he is out of the picture. But you have his girlfriend at the time, who is Michelle Troconis. Michelle Troconis, who actually Jennifer Dulas believed was having an affair with Fotis Dulas while they're still married, which then Fotis Dulas, after they got divorced, took her as a girlfriend, I guess, or continued the relationship with Michelle Troconis, and she was his girlfriend at the time. And they've got some evidence that she was actually involved with the conspiracy to commit this murder, and that she also was involved in hiding certain pieces of evidence. So there's 6 different charges that she's charged with. Number 1, the most serious, is the conspiracy to commit murder, and then you've got some other charges, which are conspiracy to commit commit tampering with physical evidence, so trying to hide evidence, that type of thing. So you've got some of those charges as well. So in total, you got 6 charges. The most important charge is the conspiracy to commit murder. So okay, that's the basics, really basic, really watered down. And of course, this trial is going to go on for a few weeks, and we're going to hear a lot more of what evidence the prosecution or the state actually has in this case. But her case got underway, and the first question that everybody is just wondering, and before we get into this, by the way, if you haven't yet, please subscribe, like the video so we can continue bringing this analysis. We've got to crush the YouTube algorithm so more people can get this message and get this important trial analysis that you're not getting anywhere else. So let's jump into this. So the first question that everyone was wondering about this trial is, why are there no opening statements? Everyone's sitting in their chairs waiting for this trial. They got the streams on, they're ready to watch this trial, and all of a sudden the judge charges the jury, basically tells the jury, which is a very nice speech about the presumption of innocence, and then right away it gets into prosecution, call your first witness, and everyone's like, hey, did we forget something here? Did we forget the opening statements? What's going on over here? So everyone's been wondering this question. Some people have been trying to answer it, but we're actually going to give you the answer, because we don't just provide the what here, we also provide the why. We give you the background and explain everything so now it's clear to you. So where should we look? Where should we look if we're trying to figure out, hey, what's going on with this procedure? What's going on with this trial procedure? What is there some sort of rule that requires opening statements or not? So if you look at the Superior Court of Connecticut, the procedure in criminal matters, this is in Chapter 42, Section 35. So of course I pulled it, and this is what it says. It's labeled as Order of Parties Proceeding at Trial, and this is how it reads: unless the judicial authority, which would be the judge in this case, for cause, permits otherwise, the parties shall proceed with the trial in the following order. So here you go. This is the rule. It's going to tell you exactly the order in which a criminal trial the order that it should follow. Here we go. Number one, the prosecuting authority, so the prosecution, the state, shall present the case in chief. Well, when we talk about presenting case in chief, that means you're presenting evidence, you're presenting testimony. So that's the first step in the Superior Court procedure in criminal matters. This is it, right out of the rule book. Number two, the defendant then may present a case in chief. Number three, the prosecuting authority and the defendant may present rebuttal evidence in successive rebuttals as required. The judicial authority for cause may permit a party to present evidence not of a rebuttal nature, and if the prosecuting authority is permitted to present further evidence in chief, the defendant may respond with further evidence in chief. Okay, so more and more and more evidence. That's also what you can, that's going to follow. Number four, the prosecuting authority shall be entitled to make the opening and final closing arguments. So you've got the prosecuting authority, so the prosecutor is allowed to make an opening closing, they're calling an opening argument, which is really what they're referring to here as the closing argument, but their first chance at it. So the prosecutor goes first, and they're calling this their opening argument, which is a little confusing, but it really just means their closing argument, and they're able to make a closing argument first, and then also after the defendant makes a closing argument, then they're able to rebut that and make a final closing argument. So you've got that, and then you got number five. The defendant may make a single closing argument following the opening argument of the prosecuting authority. So the defendant can, if the defendant wants, can make a closing argument after the state makes a closing argument. So there you go. That is the order. Now, very noticeably absent from the rule of criminal procedure for Superior Court of Connecticut, where this case is being tried, is opening statements. There's no mention about opening statements. So in Connecticut, you go straight into the evidence, no opening statements. And a lot of people don't appreciate this, because certainly the jurors could very much not appreciate this, because especially when you got a 3-week trial and you got a lot of different evidence coming in, you want a little bit of a roadmap. You want the attorneys to kind of give you a little idea of which evidence is going to come in and how they're all going to interact with each other and prove your case, or if you're the defendant, disprove the state's case, or at least provide reasonable doubt. And you don't have that. You just jump right into the evidence, and the jury has to start trying to make connections themselves. But maybe you may think that, well, hold on a second. Maybe this rule of criminal procedure is actually not constitutional. Maybe there is a constitutional right to have an opening statement be made. Ever think about that? So maybe this rule is actually not even constitutional. So how do we know that an opening statement is not constitutional, is not required, is not a constitutional right? And maybe even if you say that an opening statement is not technically a constitutional right, what about closing arguments? Can closing arguments also not technically be a constitutional right? Can a judge just say, or can the rules of criminal procedure in a certain jurisdiction say that, we're not going to have any opening statements and we're not going to have closing arguments? Just present the evidence, let the jury figure it out. What do they need the lawyers to start trying to convince them that their side is right? So maybe there's no right even to closing arguments. Maybe the only right that you have is to have a lawyer present evidence or cross-examine the evidence that the other side presents. So this is where we have to go back to the basics. So let's go back to the basics. Where is everyone's fundamental right to have an attorney present and be able to cross-examine witnesses? So really, this starts with the Sixth Amendment, right? The Sixth Amendment to the Constitution. That's what gives you the right to confront the witnesses or confront the testimony that is being, being brought against you. And also, and also it allows you to have the assistance of counsel. So not only are you yourself, if you're the defendant, do you have the right to confront the witnesses against you, but also you have a constitutional right, if it's a criminal matter, for the assistance of counsel. That's what the Sixth Amendment says. And the case law has also interpreted the Sixth Amendment to mean that not only do you have a constitutional right to assistance of counsel, but you also have the constitutional right to effective assistance of counsel. So we can't just, if you're the court here, assign some lawyer who just got out of law school yesterday, who has no idea about the criminal process or the criminal procedures, or certainly evidence or courts, or how this whole trial is supposed to work, and say, well, look, you have counsel, so you have assistance of counsel, so go ahead, you get to defend this defendant. No, you have to be able to also have the constitutional right to have effective assistance of counsel. So now this is going to come down to, well, let's say you have a court which does not allow opening statements. Can then a defendant appeal and say, my constitutional rights of effective assistance of counsel have now been taken away, because an effective assistance of counsel would mean that my counsel gets to make an opening statement. So this is where this all begins. This is really where this all begins. And you're probably not getting this from a different channel if I just had to guess. So there you've got the question of, is it effective assistance of counsel that your counsel is not giving an opening statement? So let's say, number one, let's say your counsel just decides on his own, you know what, I'm not going to give an opening statement. So then can you appeal based on ineffective assistance of counsel because your counsel, he or she, did not give an opening statement, number one. Number two is that if the judge says, you know what, we're just not going to have opening statements, and then you appeal because the judge did not allow you to give an opening statement, maybe that's also that the judge took away your Sixth Amendment right. So this actually is an actual case. This actually happened, believe it or not. It happened, and this case is called the United States versus Salovitz. And this case actually was in the Federal Circuit. It's the Second Circuit, the Second Federal Circuit. Remember, there's always two systems. Remember that. There's a state system, and then there's the federal system. And the federal system also covers certain states. So the Second Circuit covers New York, covers and also includes, it covers Connecticut as well. So here you've got the Second Circuit, which is the federal court, which Connecticut is a part of. And remember, this case is in Connecticut. And this specific issue happened. This specific issue, the judge said, we're not doing opening statements, and the defendant appealed, saying that his Sixth Amendment rights were just now violated, and therefore he should have a new trial because he gets to have a constitutional right to make an opening statement. So that's exactly what happened, and this is what the court held. Appellant's principal contention on appeal is that the foregoing ruling was error. He argues that the opening statement was an essential component of his constitutional right to trial by jury and to the effective assistance of counsel. We hold, however, that a defendant's unfettered right to make an opening statement, unlike his right to a closing argument, and listen to that again, unlike his right to a closing argument, is not one of the traditions of the adversary fact-finding process that has been constitutionalized in the 6th and 14th Amendments. So this case very clearly, United States versus Salovitz, saying that opening statements are not protected under the 6th and 14th Amendment. However, they very clearly say, unlike closing arguments, which would mean that closing arguments actually is a right under the 6th and 14th Amendment. That is a constitutional right. And you can be wondering right now, why is that? Why is it that closing arguments is considered a Sixth Amendment constitutional right and opening statements are not? I think that's a fair question to ask. But let's move on for the time being. So they continue, the Constitution requires no more than that trials be fairly conducted and that guaranteed rights of defendants be scrupulously respected. We believe that an opening statement by the defendant is not such a guaranteed right, and that the making and timing of opening statements can be left constitutionally to the informed discretion of the trial judge. So it's completely up to the trial judge. Constitutionally, it's completely up to the trial judge. He can do what he wants when it comes to opening statements. He can either say you get an opening statement, he can say you don't get an opening statement, he can do whatever he wants. He can say you get an opening statement for 10 minutes, he can say you get an opening statement for an hour. It's completely up to the discretion of the trial judge. But for some reason, closing arguments That seems to be a constitutionally protected right. Now, that should be the end of it, right? You've got this case. It's clear as day. It's in the federal circuit, so it should be completely case closed, right? Wrong. Why? Because remember, there's two separate sections. We've got the state system and you've got the federal system. So just because a federal judge decided that that's how he interprets the Constitution, is that going to bind a state court? Not necessarily. So you need to find now, all you research lawyers out there, you've got to find now a state case in Connecticut which deals with this issue and has also come out with the same holding as the United States versus Salvis. Well, don't worry, you don't have to do the work because I did the work for you. That's why you're a subscriber of this channel, because you get to sit back and enjoy the show and I do the hard work. So this case is called State versus Ridley. This is a state case, a state of Connecticut case. And here you have a very similar situation. The defendant claimed that there was error in the fact that they did not have an opening statement. And this is what the court held. The defendant's fifth claim of error is equally without merit. In this state, we have not established by statute, rule, or practice a procedure which allows the defendant in a criminal case to make an opening statement to the jury. Nor has the right to make an opening statement been construed as one of constitutional proportions. The Constitution requires no more than that trials be fairly conducted and that guaranteed rights of defendants be scrupulously respected. That is a straight out quote from United States versus Salvis. So here you have State versus Ridley incorporating the opinion of United States versus Salvis, which means that right now the United States versus Salvis case not only in the federal system is binding, but now it's also going to be binding on the state system of Connecticut, and that's why there is not going to be a right to make an opening statement. And then they make a suggestion to the court, the following. They say, whether to allow an opening statement is a decision to be left to the sound discretion of the trial court, taking into consideration the number and nature of the charges, the complexity of the issues, the number of defendants, and their interrelationship, and similar factors which, when put into proper perspective by an opening statement, would serve to clarify the issues and focus the attention of the jury upon the matters it must decide. So they're saying, here's an idea, here's a little bit of some suggestions to the trial court judge about whether he or she should allow opening statements, depending on the number of defendants, the relationship, the complexity of the issues, and then if there's a complex case, then that would be reason to have opening statements. So now we see the case law in this case is pretty clear, that it's not a constitutional right to have an opening statement. So now we go back to the rule of criminal procedure in the Superior Court of Connecticut, which is where this case is being held. And it doesn't say a word about opening statements. Now, if I was writing the rules of criminal procedure, would I just completely leave out the point about opening statements? Or would I say, if I was writing these rules, I would say opening statements are in the discretion of the judge. And the judge should think about whether the complexity of this case would be helpful to have opening statements, and then decide how long the opening statement should be, etc., etc. But it doesn't say that. It says that the order is this is the order. The order is it goes straight to the prosecution presenting its case in chief. So perhaps it may have been, if the rules of criminal procedure were written a little bit differently, it could be that in this specific case, where there's going to be a lot of different evidence, there's 3 weeks of trial, which is anticipated in this case, and there's going to be a lot of different pieces of evidence that have to be put together. And it seems that everyone who's complaining about this online would have liked an opening statement so that you can get some sort of a roadmap about what this case is going to be like, from the prosecution's perspective and the defendant's perspective. So do I think that the judge may have made a mistake here in not allowing opening statements? I think it may have been helpful for the judge to say, you know what, even though technically I'm not required to do opening statements, and sometimes it takes a long time, but in this specific case, because it might be a little bit of a complicated story here, and it could be a little bit complex, and it's going to be 3 weeks of trial here, it may be helpful to the jury. This is not talking about a 3-day trial. Seems like it's going to be a long time. So I think that it may have been helpful if this judge would have allowed opening statements in this case, although the fact that he didn't is not a constitutional violation. So there's really nothing that the attorneys can do about it, and there's nothing that the defendant can do about it. It's not an appealable issue. This issue is closed. It's done. It's dead. So there's nothing to talk about, but at least that's the basis, and now you understand why there's no requirement for an opening statement, and that's why this trial proceeded without opening statements. But as we saw, there will definitely be closing arguments. That was pretty clear from the United States of Salvas that closing arguments is a constitutionally required right that every person has, and therefore there will be closing arguments in this case. All right, well that does it for today. There is another issue which I thought came up in court, which is very interesting, which I'm going to try to also put out a video on so we can explain all of that, what's going on, and that will be for the next time. That's it for now. Please, if you haven't yet, subscribe, like this video, and we will see you next time.